Welcome everyone to our webinar on preparing your business for success in 2025. My name is Tayler and I'm joined today by my co-host Nina. Before we begin, just a couple of quick housekeeping items. First off, at the end of this webinar, you'll receive the recording and the slides in your email for future reference. Throughout the webinar, feel free to submit your questions in the Q&A box and we'll attempt to answer as many of them as we can at the end. And then at the end of the webinar, please complete the feedback survey. That's super helpful for us moving forward. Also, something exciting to be aware of, for the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. So that'll be really helpful if you've got any questions at the end of today's webinar that we didn't quite answer. That's a useful opportunity to go through those in a bit more detail. So at the end of the webinar, just provide your contact details in the survey and we will get in touch. So the purpose of this webinar is to give some consideration to the key things that you may want to think about when preparing your business for success in 2025. So first off, Nina will be discussing business structure and the potential options available for you. We will then move on to intellectual property and what you might consider protecting and how you might protect your IP. We will then move on to data and privacy law compliance. We'll then give some consideration for customer contracts and third-party contracts and how to best manage those. And then we'll also discuss employment relationships before moving on to a Q&A section. You may also receive a poll popping up. So this is just to get an understanding of the top priority for preparing your business for success in 2025. So there are a few options there. First off, optimizing your business structure for growth, strengthening contracts with your clients and team members, protecting your IP, meeting data and privacy obligations, or you may just be exploring all your options with no specific priority yet. If you could answer that poll, that would be really helpful, and then Nina can touch on those results later on in the webinar. I'll now hand over to Nina to discuss business structure.
Thanks, Tayler. The first thing we're going to be talking about today is business structuring. So to start off with, the three key structures that we typically see and which are most commonly used by small to medium businesses in particular are sole traders, single companies, and dual company structures. Each of these structures have unique benefits and legal obligations, and for those reasons, we recommend you always obtain legal and accounting advice to help you make the decision about what's best for your business. The business structure that you choose is really the foundation of your potential success. The right structure can be very dependent on your particular business, what stage you're at, the industry that you're operating in, and even your personal situation as founder. And of course, what's appropriate on day one, it might not always remain appropriate as you scale. So for these reasons, we really encourage our clients to continue to assess whether the way your business is currently structured is appropriate, taking into account your current growth, the stage of your business, as well as your plans for 2025 and beyond. Of course, having the right structure in place as early as possible is ideal, although not always realistic, as restructuring can be an involved process, especially if you have a broad shareholder base. Getting it right early on is not only helpful from a process perspective, but can also be beneficial when you're looking ahead to things like capital raising or exit events. So on this slide here, we've set out a few questions that we suggest considering to help you assess whether or not your business is using the right structure. So firstly, has your business grown in size and revenue, or do you expect significant growth this year? So any increase in size of the business means more contracts and more potential liabilities for the business. If you're currently operating as a sole trader or a partnership, will changes to your business now expose you to more personal risk going forward? If this is the case, then it might be worth looking into restructuring to a limited liability, single or dual company structure to help you to reduce that risk. If you think your business is going to be generating more revenue, then it's always important to consider whether your personal tax rate will be higher than what the company tax rate is. So as with lots of things, there's usually legal considerations and tax considerations, and usually you consider these both to help you inform what is the best structure for your business. So the next question we've got there is, has your business already generated or will it be generating valuable intellectual property? If it is, or if it will be, then a dual company structure might be appropriate. The reason for that is that with the dual company structure, key assets, including IP, are shifted into and held in the holding company, whereas contracts or arrangements with third parties and therefore trading liabilities are entered into by the operating company, and that keeps your risk captured at that level. As your business grows, you may choose to diversify and have separate companies for each arm of your business operations, which will limit the overall liability of each company to further protect the key assets. If you're already operating as a company, have you brought on more shareholders, or are you intending to do so this year? If yes, then it's important to think about having a shareholders agreement in place. If you already have one, reviewing your shareholders agreement. Does it still reflect the arrangements between all of the parties as to how key company and business decisions are to be made going forward? Also important to be aware of all compliance in terms of companies. Have any changes that have happened at the company level been reflected at the company's office? So important to do those checks as well. And finally, are your business licenses correct and up to date? As we go into a new year, it's a great opportunity to check all of these, ensure that they're renewed where appropriate and accurate and up to date. Of course, noting these will vary from industry to industry. So bearing in mind, in terms of structuring, any restructure can have tax consequences, so we'll typically work alongside you with your accountant, as I said before, to determine what the most tax-efficient structure will be for your business, and this will usually help inform and guide where you land in terms of the legal structure. We do have a number of external tax and accounting providers that we work with regularly, and we're happy to connect our clients with if you don't already have the support in place. We also have a lot of freely available content as well. Talking to business structuring, we'll be happy to share with you if you consider that your structure needs revisiting. I'll now pass over to Tayler, who's going to talk about intellectual property.
Thank you, Nina. So as Nina touched on, there are some structuring considerations that you can put in place to protect your IP, but it is important to regularly ensure that your intellectual property is adequately protected. So you may want to consider your current IP. So this includes your branding, including your business name and your logo, and these are absolutely assets of your business which may be worthwhile protecting. You may also want to look into the trademark registration process, but I will note that this can be a long process from the date in which you lodge your application, so it is certainly best to start this process early. You should also do regular checks to ensure that your brands and product lines are cleared for use to avoid infringing any third-party rights. And while IP registration, such as trademarks and patents, is obviously important, so too is the contractual side of IP ownership. When considering future IP and the contracts that you're entering into, as you expand your brand and perhaps add additional trademarks, slogans, and business names, it's important to continue trademarking and protecting these as well. So if you are expanding overseas, you might want to consider whether you require trademark protection in these overseas jurisdictions as well. And when you enter into a contract with a third party, depending on the nature of the goods or services to be provided, new intellectual property may be created when the parties perform their obligations under that contract. So your contract should contain clauses which detail which party owns the intellectual property that is used or created after the contract is entered into. In this regard, a contract should consider ownership rights in respect of any IP that is owned prior to the contract being signed, IP that is created or developed under the contract, and any improvements made to a party's pre-existing IP or to the IP created or developed under that contract. So you'll want to consider who will own the rights in each of those distinct sets of IP. You should also consider whether you will need a license to use the other party's IP and whether it would be a good idea to give the other party a license to use your IP. So for example, if you need to use a third party's IP to provide your services, this should be included and acknowledged within your contract. If you're going to be giving the other party deliverables, which will include your IP, then the other party will also need a license so that they can use those deliverables. So the scope of the license can vary considerably among contracts, and that's really a commercial decision, but it is very important to consider. So you may want your license to be revocable, meaning it can be revoked or removed by you. You may want it to be transferable or sub-licensable. You may want it to be royalty-free or paid, meaning someone may or may not need to pay to continue using the license ongoing. You may want the license to only last for the term of the agreement or ongoing, or you might want the license to be limited to a specific purpose. So those are all really important commercial considerations to think about when using your own IP and sharing and using other parties' IP as well. In terms of ongoing monitoring with your intellectual property, it's important to regularly check whether other businesses are using your registered trademarks, and if so, take action, such as sending a cease and desist letter to enforce your rights to exclusively use that mark. And LegalVision can certainly assist with tracking your trademarks and assisting with enforcing any breaches of that trademark as well. So I'll now move on to pass on to Nina to talk about data and privacy.
Thank you, Tayler. I'll just at this juncture also refer back to the poll where we've received pretty even results on all of the answers that were available there. But I will note that data and privacy obligations received the lowest number of votes. So I think that's a timely thing to point out going into this data and privacy section, because it is absolutely something that sometimes falls to the bottom of priority lists for businesses. But given that pretty much all businesses will collect personal information from customers, sometimes, suppliers and others, it is a really important thing to be aware of. And, the consequences of not looking after your data properly can notably cause real reputational damage to businesses. So it's something that we really encourage you to keep at the forefront and just be making sure that you're complying with all your obligations regarding data and privacy as you go alongside all the other things. So just to go through the slide here, at a high level, any business that collects personal information is required to comply with the requirements under the New Zealand Privacy Act. So that act governs how businesses collect, use, and store information. Personal information is defined as information about an identifiable individual. So that includes things such as names, emails, physical addresses, photos, things like that. So if you do collect this information, you're required to have a privacy policy, and there's certain things that need to be covered off by that privacy policy, such as the types of personal information that you're collecting from your customers and others, how and for what purpose that information is being collected, held, used, and disclosed, whether you're planning to disclose that information overseas, and there are some other requirements that apply in terms of if you're thinking about doing that. And you also need to set out how your business will deal with any privacy-related complaints, amongst numerous other things. It's really important that your business's privacy policy is reviewed regularly to ensure that it's compliant with the laws that are applicable at any point in time, and also that it's up to date with the current privacy practices that your business has in place. So for that reason, we usually suggest to our clients that this document is reviewed every year and that you consider it more of a living document rather than something that you put in place and forget about. Another key aspect of data and privacy that all businesses should be turning their minds to is whether you're prepared for a notifiable privacy breach. So what does that mean? If your business suffers a privacy breach that either has caused or is likely to cause anyone serious harm, then you must notify the Privacy Commissioner and any affected people as soon as you're practically able. Examples of serious harm that could be caused from a privacy breach include physical harm or intimidation, financial fraud, that includes unauthorized credit card transactions or credit fraud, family violence, psychological or emotional harm. The Privacy Commissioner has a really useful website, and that includes a notify us function where you can make the required notifications. From an internal business perspective, we recommend having a privacy breach response plan prepared and ensuring that the relevant people within your business know how to action it. This response plan is an internal policy that outlines the process your employees should take in the event of a data breach and who's responsible for any escalations that need to take place. Finally, we also recommend making sure you have adequate software and security in place to really protect that personal information that you hold, make sure that it's securely protected and stored. The best case scenario, of course, for all businesses is that you never suffer a data breach. As I mentioned before, it can cause reputational and other damage to your business, but it's important that businesses are prepared for the eventuality if that happens. So now I'll pass back over to Tayler, who's going to talk about contracts.
Thank you, Nina. So you may be asking yourself, do your customer contracts or your terms and conditions need to be updated? It is always a good idea to have your customer contracts and terms and conditions reviewed regularly to ensure they are compliant with any recent law changes. The main pieces of legislation which protect consumers in New Zealand are the Consumer Guarantees Act and the Fair Trading Act. So these impose minimum standards or guarantees that your business must comply with when providing goods or services to consumers. And they also detail things like ensuring that you're not participating in any misleading or deceptive conduct. There is an amendment to the Fair Trading Act that's just recently been passed, which results in a change to the sale of gift cards. So this change in the Fair Trading Act, which won't come into play for, I think, another year, will require any businesses who sell gift cards to ensure that they have an expiry date of not less than 3 years from the date of sale. So if you sell gift cards, you will need to ensure that you update your terms and conditions and your gift card issuing processes to ensure compliance with that change. And that's just an example of the changes that can be introduced to consumer law or applicable laws or regulations that apply to your business. So it's certainly a good idea to keep your terms and conditions up to date, have them regularly reviewed by a lawyer, and ensure that you're compliance with any applicable legal changes. Moving on to third-party contracts, you may also be asking yourself, do you have the right contracts in place for your clients and for your team? So focusing on distribution contracts, firstly, if you sell online, then theoretically you could sell all around the world. However, if breaking into overseas markets is a challenge, you may choose to set up distribution channels where you have an overseas distributor who knows their market, they have a good relationship with the customers in that location, and they can help facilitate and manage those relationships in that territory for you. So that's certainly a helpful avenue for businesses looking to expand globally. If you've worked out that you have enough products to export and to supply into the markets at which you're expanding, and you've set up arrangements with distributors in the countries in which you plan to sell, you'll need a really solid distribution agreement outlining the rights and responsibilities of your distributor. And that will obviously consider things like payment terms, general clauses like privacy, confidentiality, liability and disputes. And then it may also consider more commercial things such as, how does the order process look like? What does the payment process look like? What are the distributors receiving in return for the work that they're doing? So there are a lot of commercial considerations to put into that contract, but it can certainly be a helpful tool for businesses. You may also want a general supply agreement in place. So that would be a service agreement which should be in place with individuals or businesses who supply goods or services to your business. So do you engage manufacturers to manufacture goods for you? If so, make sure that you have an agreement in place describing the manufacturer's obligations, including shipping and delivery, confidentiality requirements, and an obligation to fix defective products or assist with recalls if there is an issue. You may be engaging a development firm to build an app for you or update your website. In this instance, you would also want to ensure that the agreement has an acceptance testing regime to allow you to approve or reject whatever they're creating for you. You may want to include milestones for payment, and you may also want to specify IP ownership. That will be really important where you're engaging a third party to create or develop something on your behalf. Software contracts are also increasingly more important and relevant for modern businesses. So you're undoubtedly going to be using a variety of software when running your business. This may include client management systems, marketing providers, team collaboration and communication platforms, or even payroll software and third-party payment processes. Or maybe you are actually offering a software as a service yourself. So each of these software providers will have a software as a service or a SaaS agreement or terms and conditions for you to accept and potentially negotiate. So you should always have a lawyer review these so that you're aware of any potentially unfavorable terms. For example, if you're handing over client data to these providers, are they going to keep this information confidential and comply with New Zealand privacy laws? So there's always things to consider and be aware of. So you should also always review those contracts before entering into them. So depending on who the supplier is, whether they're a larger company with their own contract or a smaller company who may be open to entering into your own terms, you will need contracts drafted or reviewed, and LegalVision can absolutely assist with that. I'll now hand over to Nina to talk about employment relationships.
Thank you, Tayler. So just rounding out the high-level key things to think about, setting your business up for success. Employment is a massive realm, and it's really important to be aware of any recent changes that come into effect under employment law. Make sure that your business is remaining compliant. We've just covered off a high level, some changes that have occurred in recent times to be aware of. So as of late 2023, there was the reintroduction of 90-day trial periods. Hopefully everybody's all aware of that at this point. That change meant that 90-day trials can now be used by all employers, provided certain criteria are met. New introductions were introduced, and new requirements in the Worker Protection Act were introduced, which are aimed at preventing migrant exploitation. There was a repeal of the Fair Pay Agreement legislation, an extension of time available to employees to raise a personal grievance in regards to sexual harassment, which increased the relevant period from 90 days to 12 months. And lastly, under the Employment Relations Amendment Bill 2025, currently before Parliament, the government has very recently proposed significant changes to the Employment Relations Act 2000, focusing on employer flexibility and procedural fairness. We don't have time to go into all of these changes in detail today, and they might also not be relevant to everybody on the call. However, if you do have employees in your business and are interested in learning more about them and how they may impact you or your employment team, our team is running a free webinar on employment essentials at the end of this month, and we encourage you to come along to that. The changes that come through are a great opportunity to revisit your business's employment documentation, such as the template agreements that you use for your employees and contractors, internal employment policies that you have in place, to make sure that they are compliant with the law, up to date, and relevant for your business going forward into 2025 and beyond. From a corporate perspective, this can help impact the success of due diligence that's undertaken when you're going into a capital raising or an exit event transaction, or any potential investors will be reviewing this documentation as part of their due diligence to ensure compliance with relevant laws. You can, of course, also use your free LegalVision consultation to speak to one of our employment team about these changes. So that concludes the main part of our webinar. You might find our publication with tips on how to perform a legal health check on your business useful. You can access that in the resources tab of this webinar or by scanning the QR code on the slide here. As I mentioned, we've also got an upcoming event which you might be interested in. It's on employment essentials for startups that's been held at midday on Tuesday, the 25th of February. And if you'd like to register for that, you can do so at the URL. So the next thing we're going to get onto is some Q&A, but before we do that, we're just going to take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, unlimited domestic trademark registration, and much more. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are an in-house counsel, we also offer a dedicated service to help manage your high-volume business as usual legal tasks. If you'd like to learn more about how our membership or desk extension service can help you, please request a free consultation when the survey appears at the end of this webinar. So we've received a lot of great questions from the audience today. We won't have time to go through all of them today, but we'll answer a couple each, and then please do follow up with any other questions we weren't able to get to. Tayler, would you like to take a first question?
Absolutely. So we've got one question that was sent through in advance of the webinar, and this is how can businesses effectively manage their third-party contracts? So it's often easier as a business if you've got your own standard set of terms and conditions or a go-to kind of agreement that you use. Obviously, if you're entering into third-party arrangements with your own contracts, then there's consistency there. It's easier for record keeping, and then you kind of have a standard set of terms that you are aware of and can be firm against. However, if you are agreeing to contracts provided to you by a third party, then you should absolutely seek legal review of these before entering into them. And it can often be helpful to compare these against your own standard terms so you can understand, where the differences are and what's a primary concern for your business and what you'd like to push back on. In terms of actually manage your contracts, you should obviously store signed and dated versions and track any changes to the contracts, and your contract will tell you if that needs to be done in writing via a signed variation or just otherwise as agreed between the parties. But it is helpful to keep these stored in a secure location. For example, LegalVision has an in-house tech platform called Prism, through which all of our clients store and manage their documents, and we correspond through there. But any system that you have access to can be helpful in terms of managing those.
Awesome.
I'll pass over to you, Nina, for a question.
Thank you, Tayler. Sure. So one of the other questions we've received is, what is the best small business structure when first starting? So hopefully, as you took from the beginning of the webinar, it really depends on the circumstances of the particular business, what your goals and aspirations are for your business going forward. We often encounter people who are at the start of their business journey, who have just kind of got their business off the ground and they're operating as a sole trader. A sole trader can be really great when you're first starting because it's really easy. You're just running your business in your personal name. The downside of the sole trader approach is that you're personally liable for all of the risks, the debts and liabilities of your business. And so for that reason, we would usually see businesses pretty quickly moving into a company structure, which in our view is ultimately, the best structure for most businesses, with the key benefit of the company structure being the limited liability that it affords. It means that, as you're going on, your business is growing, you're protected from all of those debts and liabilities that the business is incurring. I guess if your business is always going to be really, really small and it's low risk in terms of those debts and liabilities, then you might stay as a sole trader. But if you're hoping to kind of expand and grow, which is most of the clients that we work with, you would look to restructure into a company, if not a dual company structure. Awesome. Do you want to take the next one, Tayler?
Absolutely. So someone sent across a consumer law question. What if someone leaves a negative review on my website? So under New Zealand consumer law, you're not able to delete or hide any negative reviews. So the best approach is absolutely to acknowledge a review, respond to it politely and publicly, and ask to resolve the issue privately, such as via email. If you can fix the issue and rectify the customer experience, then the customer may delete their negative review. Alternatively, for any new potential customers reading your reviews, they will see that you're acknowledging the issue and resolving it, which is reassuring. But you are required to leave those negative reviews live on your website, and just hope that you can mitigate receiving those in future and kind of address and resolve the issue moving forward.
Awesome. Thanks, Tayler. Another question related to the one I answered before. Somebody's asked, how do I go about restructuring my business? So there's, a few different restructures that can occur depending on what you're hoping to do for your business. So if you're restructuring from a sole trader and you're wanting to move into a company, that basically requires that you transfer all assets and liabilities and third-party arrangements that are attached to your business from your personal name into the company that you set up. So notably, that includes employees need to be transferred, and just noting that, again, when it comes to employment law, there are really specific laws and regulations that apply and processes that need to be followed. So that's something we absolutely recommend getting advice on, transferring any existing employees, any contracts that you have in place with third parties, whether that be suppliers or your customers, and transferring all of the IP and any other assets that the business owns from your personal name into the company. It's a bit more complicated when you're wanting to go from a single company to a dual company structure. And so for that reason, again, always recommend getting advice. It basically requires, setting up a new company, which is your new holding company above your existing company, and then transferring your shares in your operating company up to the holding company level. And that's done in exchange for new shares being issued in the holding company. And then again, there's the transfer piece. You will already have everything contained within your existing company, but you would transfer all of your valuable assets, including the IP, up to the holding company to make sure that you have that protection. And again, in terms of, when you're thinking about what's beneficial, if you're considering bringing on investors and doing capital raising, or if you're looking for an exit, these sorts of third parties are particularly usually interested in or find the dual company structure to be a favourable structure. And the reason for that is because, of course, with the assets of the business contained at the holding company level, they're siloed and protected from the debts and liabilities of the operating company. And that means that correspondingly their investment is also more protected as well. So again, just to reiterate, if you see that, if that's in your plans for 2025 or beyond, you might want to consider whether or not that's a structure that you look at doing this year as well. Get some advice on, have a chat with us about whether or not that'll be appropriate. Any more questions at your end, Tayler?
Yep, I've had another one come through. What to do practically if I think a privacy breach has occurred. So it's important, first of all, to take action to contain the breach and obviously prevent any further unauthorized access. And you should then evaluate the nature and extent of the breach, including what personal information was involved and who you think may be connected. As Nina flagged, the Privacy Commissioner's website has a really helpful feature called Notify Us, which asks you a number of questions to help you determine if you need to notify the Privacy Commissioner of the breach and if you need to notify any of the affected individuals. So that will vary on a case-by-case basis. You can then investigate the cause and take action to prevent further breaches. And in terms of a kind of record-keeping risk mitigation approach, we also recommend all our clients keep a document and record of the process that they took in relation to the breach and in response of the breach, including the cause and your response to it. So those are always things to think about and document. Awesome. Nina, do you have any further questions pop up?
Yeah, thanks, Tayler. We've had some questions around, how do you sort of tackle your legal obligations if you've got a low budget and you can't potentially afford to get legal representation at this time? I think, it's a great question. Obviously, getting some legal advice is always the best course of action, and that's how you'll best ensure that you are protected and compliant and set yourself up for success going forward. However, I would probably point you to the many legal resources that we've got available on our website. We've got lots of webinars like this available on YouTube that you can look at to kind of inform yourself around the sorts of things that you need to be considering. There's also lots of other really helpful resources available online. For example, the Companies Office has lots of great free resources. There's a business.government.nz website, which has lots of great information for businesses getting off the ground. So yeah, getting legal advice is really the best way to do it. But otherwise, I would point you to our website, point you to government websites that have good advice. Just beware of, checking your sources where you're getting information from to make sure that it's actually reliable. And, at some point as your business kind of starts generating some revenue, then would recommend that you seriously consider getting some legal advice at that point in time. Anything else at your end, Tayler?
Nothing further from me.
Okay, fantastic. We've got quite a few questions that have got quite specific fact circumstances in them, so not really appropriate for us to answer in this webinar, unfortunately, but this is where we would really encourage you to submit any follow-up questions that you have in the survey that will pop up at the end of the webinar. As another sort of general comment, I would say that we've also received some questions around overseas jurisdictions and operating in other countries. So just to say on that, each jurisdiction or each country in the world has got obviously its own laws that apply, so we're only able to advise on the laws that apply in New Zealand. So if you are thinking about expanding your business into a different country or even setting a business up in a different country, what we would always recommend anyway is that you seek some local advice to make sure that you understand what that framework looks like over there and make sure that you're compliant in whichever area it is that you're thinking about operating in. So awesome. Once again, sorry if we weren't able to answer your specific question today, but if you would like to receive a copy of our slides, recording, and the publication that we've referred to today, please do complete the survey at the end of the webinar. You'll receive those resources. And if you'd like to book in your free consultation with LegalVision to discuss how we can help your business with your legal needs going forward, please do provide us with your contact details, and then somebody from our team will be in touch. And while this is a free webinar, as Tayler said, we really value your feedback, so please do complete the survey at the end. We hope you got some value out of today. Thank you so much for joining us, and hope you have a wonderful rest of your day.